Court of the State of Washington is now in session.
Thank you. Please be seated. Good morning. Welcome to the Washington Supreme Court. We're hearing two matters today, June 11, 2024, here at our temporary facility in Tumwater. Justice Whitener is here appearing remotely on the screen to my right. The first matter is In re Troy Kelley, WSBA number 30998. Opening is Troy Kelley for 13 minutes. Response from Benjamin Atanasio for 20 minutes, and 7 minutes reserved for rebuttal. Counsel, please proceed.
Thank you. Good morning, Chief Justice and Justices. I'm joined today by Jack Connolly of Tacoma with me at the council table. This court should hold on the narrow issue that when ODC is seeking disbarment, ODC must present more than a 1 or 2 page jury verdict, which severely limits how a hearing officer can exercise discretion in her decision. ODC recently stated on the record that's all we need to do. I disagree. I'm not a practicing attorney and have no intention to be. I'm here today to ask this court to remove any ambiguity and clear this up for any of those who come to you in the future under this process. I'm not an expert in attorney discipline. That said, I've watched arguments before this court and read the numerous transcripts from the Disciplinary Board on attorney discipline. In every case, both bodies are interested in the facts and the conduct that gave sense to give them a sense of what happened here. Not in my case. There's been no interest in the facts. I argue that ODC needs to present facts of wrongful conduct for discipline, not simply the wording of the United States Code. To do less removes any discretion from the process weighing aggravating and mitigating factors under the ABA guidelines. And that's why we're here today. We're looking at those factors and at the end of the day, what the attorney discipline decision should be here.
Could you address what you see under the rules for lawyer conduct and under the ODC process, the role of determinations in a criminal case? Because discipline abides while a criminal case is going on, and some of the dispute here seems to be about whether they can rely on the determinations in the criminal case.
Well, first, let's agree that the conviction is stipulated to. There's no question with regard to the conviction, and that is something that's before you. So based on the conviction alone, there should be some attorney discipline. I don't think we disagree about that. I think we disagree on the level of discipline and the lack of discretion by just taking a, again, 1-page jury verdict and presenting it to the hearing officer and asking for a decision for disbarment, which is basically the attorney death penalty, with nothing in between. There was a, what you call settlement conference here, but there was no real discussion. I went in good faith and attempted to negotiate different possible outcomes. They told me only one outcome was possible. And I think we'll get to that in a little bit, where the hearing officer said he has little or no discretion in this matter. Again, that is based on the criminal conviction. But you need to look at the facts. Each conviction is different. Each case is different. We don't have to go much further than to look at some of the convictions in Georgia just recently.
What can we look at the facts behind the conviction? What are the facts behind the conviction relevant to? Because the fact of a conviction, if it's for a certain type of crime, under the rules, warrants discipline. That alone, just the fact of the conviction,
Agreed.
If it's for a certain type of crime.
Agreed.
So what are the facts behind the conviction relevant to?
They are relevant to the hearing officer exercising discretion in terms of the type of discipline, suspension, any other sanctions, including up to disbarment. But when they're not looked at, when the facts are not looked at, and I'll give you a couple right now, in terms of what I believe was important. Under the ABA standard 922, under dishonest or selfish motive, the hearing officer basically made a decision that, well, let me go through the facts here. My business charged a $125 fee. That was something that I was not charged with theft for. That was something that was created by the prosecutors argued, an unsigned implied contract. That, I think, needs to go into the determination of the hearing officer. This is not a typical case of theft. This is not a typical case of an attorney taking from a client. This is an argument that was created that 2 grand juries didn't agree to indict on. The third finally did, even though they didn't hear actual testimony.
Well, the way I see it, the jury disagreed with that,
No, this is the second jury, not the first jury.
the one that convicted.
Correct.
Which is the one that's in front of us. They disagreed with that view of the facts. So I don't think we get to relitigate them here. I do agree that the hearing officer needs to consider a lot of things in determining the correct sanction. But I'm not sure that the type of theft is relevant unless it bears on something like intent or willfulness or your mental state or one of the other listed factors that they can consider. Are there facts that you're arguing that are not made conclusive by the jury's verdict and the conviction, so they're still open for the hearing officer to consider?
Correct, and let me just address that directly. I believe that there's a departure here with regard to the ODC pleadings in the case, and it's troubling to me because this disbarment typically requires moral turpitude and requiring a known legal duty that's been violated in terms of that I intended to violate that. But if you look back at the federal conviction, that they've said only the intent to take the actions complained of and not the intent to break the law. And this is an interesting case because for the most part, we don't disagree with the actions that I
What are you
took.
quoting from when you say that? It wasn't clear from your briefing what that's supposed to be a quote to.
I'm quoting mostly from the federal court case. And I have a couple.
I understand. Is it the jury instructions? Is it what the judge said? Is it what a lawyer said?
It's what the judge said. And I can give you a couple specific quotes here. The federal judge also said, ignorance of the law is no excuse. Defendant did not need the intent to break the law. The prosecutor went so far to instruct the jury, the prosecutor, not the judge, that defendant is guilty of theft if he picks up a $10 bill from a deserted street. We only need to know that the $10 bill is not his. We do not have to prove it belonged to someone else. And just for the record, I did not pick up money from the deserted street. I charge clients a fee under a signed contract in each case.
I looked through the record that was in front of us to try to find the quotes that you're talking about, and I didn't find them. But it's a limited record that we have. I don't know if you're talking about jury instructions or something else. Maybe a conference with the lawyers?
No, the last quote I just gave you is from the prosecution's closing argument with regard to the $10 bill story, that if I pick up a $10 bill, I'm guilty of a crime.
So
the jury agreed with that.
Typically what I would look at would be the jury instructions to determine what the jury had to find in order to convict.
Good
And
point.
I didn't see them.
So the jury instructions included a couple things that were fought over it by counsel. The key point that we disagreed with was that the money did not have to belong to anybody. The money that I charged did not have to be taken from either the homeowners or from the title company. That is, I charged a fee.
The Ninth Circuit and the District Court both rejected that argument. The Ninth Circuit specifically said, even if they needed to prove that, the government provided enough evidence. I'm sorry, I'll let you have more time. You have 5 minutes left.
On that point, the government made no attempt to show who the money was taken from at the end of the day, and there was no need for them to conclude that.
I wanted to make an observation. You mentioned it was like the death penalty. I don't want to minimize the seriousness of someone losing their license to practice law, but there is an ability to be reinstated after a period of 5 years, isn't there?
There is, correct. It's something similar to the death penalty as for an attorney. The death penalty, we have a lot of people that are on death row that get off because they're exonerated. This is a different case. I would argue that I've been suspended for, as you read from my pleadings, I've been suspended formally from the bar for 6.5 years.
Well, let's ask about that. Does that period of suspension get treated like credit for time served, since we're doing criminal analogies here? Or is it irrelevant to the sanction that's eventually imposed?
You'd have to ask the bar. But I know in some cases they do give you time served for that time period. So again, it's been 6.5 years since I've been formally suspended, interim suspended, and it's been 9 years since the initial indictment I have been able to work. So again, we're looking at a 9-year period. If I'm disbarred, I could probably begin the procedures possibly immediately. If not, I'd have to wait another 5 years. I'm turning 60 in just a few months. The question at the end of the day on that point is, why is there attorney discipline? Attorney discipline is to protect the public. Does the public need to be protected more than the last 6 years that I've been suspended, the last 9 years that I haven't been able to work? I mean, that's the question. Is it another 5 years that's necessary, another 10 years? It's not meant to discipline the attorney unless I'm misreading it. It's meant to protect the public. Criminal courts are different. There's several different components. So that's what I would argue, that I would say that needs to be at least considered. It's not a direct mitigating factor or aggravating factor.
And so the discussion was of a conviction. There were 8. Is that correct?
That's correct.
So possession and concealment of stolen property, making false declarations, and filing false tax returns.
Correct.
Do you break those into categories and treat them differently, or are you saying that they're all somehow of a piece because they were in the same prosecution?
Basically, they are based on the linchpin crime, which is possession of stolen goods, basically. And again, it's a tough analogy since they've taken legislation originally geared at going after European art stolen by the Nazis. So that's the initial.
How does that inform the income tax return?
That's a very good point. The income tax point, and I want to raise it specifically because the hearing officer said that it was a aggregating factor under dishonest or selfish motives. How does it affect it? I've basically been charged with overpaying taxes. Look very closely at the charge sheet. I'm not charged with perjury, and in this specific case, I'm not charged with tax evasion. It's a false statement of taxes. They say that I paid not enough taxes in 1 year, but overpaid in other years. And you probably know what I'm going to do next. I mean, this has been over a decade, and they haven't, cleared up what they owed me. And yes, Justice, why after the first trial are they sending me a check for $460,000? It's in the record. Why after this last issue where I raised with them, they're sending me another checks for $90,000? I mean, the checks have been, they're still coming. I've got over $600,000 already from the IRS. They refused to audit me, and they still owe us another $20,000. I think those are things that need to be considered by this court.
Are you saying those should be considered as mitigating factors? And as you answer that question, could you specifically say what discipline you're seeking?
First up, with regard to mitigation, I'd say yes, but more importantly, I'd say it's not an aggregating factor. The hearing officer said it was an aggregating factor. I think that's just wrong. 2, what discipline am I seeking? Typically, the bar only suspends people for 3 years. I would ask that my entire suspension be written up as discipline, and then I'd be reinstated inactive, not active attorney. I don't seek to practice law in the future. This is important to me in order to continue my public service and in order to make the point. I say I only have a few minutes left, but as you saw from the brief, there's many other issues here with regard to disbarment. I'll just address one in my 33 seconds left. The court currently, I guess, backs the decision, was it 184, that says a former attorney can't work for an attorney other than to mow lawns and wash windows. I don't know if the court has jurisdiction to say that about former attorneys. So I just think that's something that needs to be cleared up. And I guess I will take questions after, on my rebuttal phase, because I do see my time is up. Thank you.
Thank you. Response, please.
Thank you. May it please the Court. I'm Ben Attanasio on behalf of the Office of Disciplinary Counsel. Mr. Kelley has been convicted of 8 federal felonies. Those convictions have been upheld on appeal, and the criminal case is over. We are here on the appeal of a disciplinary decision based on those convictions. This is not another opportunity for Mr. Kelley to challenge the convictions or to review the facts underlying them. The only issue before the Court today is the appropriate sanction for a lawyer who has committed the felonies that Mr. Kelley has been convicted of. The hearing officer and the disciplinary board recommended disbarment, and ODC asks that the court adopt that recommendation.
Counsel, I have a specific question about count 1, which is the possession and concealment count. I'm aware that the other counts have willfulness, a higher level of intent as elements of the crimes. I don't see that in the possession and concealment count. And although you listed in your briefs as possession and concealment, It was charged, and it was charged in the conjunctive. Typically in federal court, they charge in the conjunctive but instruct in the disjunctive. So a person can be convicted if they did any one of the list of the crimes, not necessarily concealment, but possession. Again, I looked through the jury instructions to see if I could figure out what was the basis of this conviction, and I could not. Do you know what the basis for this conviction is? Because your briefs consistently say that it was concealment, which requires a higher level of intent, but I couldn't find that.
So the charge in the superseding indictment was for possession and concealment in the conjunctive, as you say.
Can you speak a little bit louder, or I can put this on?
Sure, I can adjust the mic here. The charge in the superseding indictment was for possession and concealment. As the hearing officer found, Mr. Kelley was convicted as charged, and that's an unchallenged finding of fact at paragraph 12.
Okay, but that's not accurate, because the U.S. Attorney's Office, as I said, charges in the conjunctive using and, but the judge instructs in the disjunctive. I didn't see any jury instructions in this packet, but I know that's how they instruct. That mean in an alternative means crime like this. And I know that any one of those suffices to prove the crime. So I disagree with I think that's a legal point, and I disagree with your view on that. I think it's possible that he was convicted of just one in the list, not all of them. That means that I disagree with your argument on why count one necessarily compels disbarment.
Well, count one also falls under ABA standard 5.11a, which is conviction of a serious crime, including any number of elements. It does not contain a specific state of mind requirement, intent or knowledge, as other ABA standards do. The fact of the conviction creates a presumptive disbarment under 5.11a. So count one, along with all the other counts in this case, fall under that standard, as the hearing officer found. The hearing officer also made an independent finding that Mr. Kelley acted intentionally based on the information before him. There was not information in the record presented to the hearing officer regarding the jury instructions or any other information to mitigate. Mr. Kelley had that opportunity at the hearing, and it's not in the record here.
Following up on that, based on the counts that were charged, you said the presumptive sanction, I think you were just addressing count one, was disbarment.
Yes.
Can you address what you think was the role, if any, of the aggravators? So Mr. Kelley mentioned that, certain factors that were found, I think, by the hearing officer as aggravating factors. If those were not treated as aggravating factors, what would have changed?
So can I just clarify, is your question if there were no aggravating factors present in this case?
If there were no aggravating factors, given the presumptive ABA standard sanction, what would have changed?
I don't believe the ultimate sanction would have changed. I don't think the aggravating factors brought this up to disbarment. The presumptive sanction in the first instance was disbarment under 5.11a. These are 8 convictions for crimes of dishonesty. These are felonies. Even with the presence of absence of prior discipline and character and reputation, which are the mitigating factors, just because those are present, they do not necessarily automatically reduce the sanction. This court has found in Ray Presler and in Ray Rodriguez that the mere presence of those factors does not necessarily mitigate severe misconduct from disbarment. So, in answer to your question, even if none of these aggravating factors were present, I believe the appropriate sanction here would still be disbarment.
I was curious about your view on the suspended time question that I asked Mr. Kelley.
Yes, so under the admission and practice rules, which govern reinstatement from disbarment, if a lawyer is interim suspended during the pendency of their disciplinary proceeding, they essentially do get credit for time served. So a lawyer who is disbarred can petition for reinstatement 5 years following the disbarment. They can be reinstated 6 years after, so any time on interim suspension would credit towards those time periods.
So he'd be able to petition for that right away, essentially?
I believe so, yes. He's been interim suspended since, I believe it was December of 2018 at this point.
I want to make sure I'm understanding your answer. So whether the ultimate sanction be disbarment or suspension, that credit applies, and you're saying Mr. Kelley could immediately petition for reinstatement?
So I'm discussing the way it applies for reinstatement from disbarment, which is governed by the admission and practice rules. There is a specific rule regarding the application of interim suspensions. If the ultimate sanction imposed were a suspension, there is not a specific rule governing how an interim suspension applies. This court has, in at least one instance, applied the time of interim suspension to the ultimate suspension that was imposed, and that's an in re curren. But the court has not found that interim suspension would work as a mitigating factor to mitigate a presumptive disbarment down to a suspension. In the current case, the presumptive sanction was a suspension in the first instance.
But you said that the application for reinstatement could be considered sooner than what the rules would ordinarily provide if there had been a lengthy suspension period. Did I understand you correctly?
The petition for reinstatement from disbarment. So there's different procedures.
Right.
If you're being reinstated from disbarment, that's governed by the APR. That goes to the Character and Fitness Board. It's a different procedure, different procedural rules. Whereas reinstatement from suspension is governed by the rules for enforcement of lawyer conduct, and there's not the formal petition that is required for reinstatement from disbarment.
Do you know the particular rule that would apply under the admissions, application for admissions rules?
It's within APR 25. There's a number of subsections. I apologize, I don't recall at the moment the specific subsection under APR 25 regarding interim suspension.
Thank you.
Counsel, I have well, it feels like a little bit of an unimportant question, but it's nagging at me. If Mr. Kelley's able to reapply for licensure effectively now, if we're, based on your answers, and he's been suspended for over the period of time that would allow him to do so, what's the purpose of the court entering a finding of a disbarment today? What's the effect?
The effect is that to be reinstated, Mr. Kelley would still need to go through the procedures under the APR to not impose disbarment and decide that he could be reinstated under the APR, and therefore you shouldn't impose disbarment, would essentially usurp the role of the Character and Fitness Board and apply the disciplinary procedural rules to essentially reinstatement proceeding, which is, there's different procedures, different rules, there's a different burden. The burden is on the applicant. So it would short-circuit that process, essentially. This is not a reinstatement proceeding. This is a proceeding to determine what discipline should be imposed in the first instance.
So once he's applied through that process and goes in front of the Character and Fitness Board, they're assessing his suitability to regain his licensure under those rules based upon what we know now. Is that right? His history up to now.
Yes, and I believe that in the petition for reinstatement, someone who's seeking reinstatement can provide additional information regarding how they've reformed and things like that. I don't know all the ins and outs. That's something outside the Office of Disciplinary Counsel's work. But the Character and Fitness Board would certainly look at the prior discipline and any other information that the applicant is permitted to submit in the reinstatement proceeding at that point.
The discussion of community service or the lack of it, is that relevant before us at all?
I'm sorry, I don't understand the...
When mitigating factors were being considered, it seems like community service or the lack of it was reviewed and discussed. Is the attorney, whether they engaged in community service, relevant to what we've decided or what was decided below?
It could be relevant to mitigating factors. Here, the mitigating factor of character and reputation applied, and I believe that's what you're referring to. Colonel Cooper testified at the disciplinary hearing regarding Mr. Kelley's character, and I believe that that's where some of that information came in. The hearing officer did credit Mr. Kelley with character and reputation as a mitigating factor. We're not disputing that. There's evidence in the record. Again, though, Mr. Kelley had the opportunity to present information in mitigation in this case. Much of the information that he refers to in his briefing is outside the record. There are no citations to the record, so it is difficult to parse what, in fact, he's discussing that is, in fact, in the record and properly before this court. But
in response to, I think it was Justice Stevens, asking what would happen if there were no aggravating factors, you said the outcome would be the same. But don't the mitigating factors mean that we don't know what the outcome would have been in the absence of the aggravators?
Well, I took Justice Stevens' question to mean if the 4 aggravating factors here were essentially tossed out and you were left with the 2 mitigating factors, which ODC does not dispute, absence of prior discipline and character and reputation, how would that affect the presumptive sanction? In our view, they are not sufficiently mitigating to reduce the sanction from disbarment. If there are other mitigating factors that could have been proven, Mr. Kelley had the opportunity to do that at hearing, but the hearing officer didn't find anything beyond those 2. He argues in his briefing for a number of other mitigating factors, but again, doesn't cite the record and discusses information that is outside the record regarding, for instance, restitution, which was compelled by the felony conviction, recurrence, and other things that are not mitigating factors under the ABA standards, and he hasn't cited anything in the record or any authority to support the application of those factors.
Can you address, I wanted to ask about the intent piece or the specific knowledge piece, because Mr. Kelley argues that the underlying conviction didn't require, the sort of moral turpitude, knowing violation of the law or knowing violation of a code provision. And it's clear that ODC is relying on the fact of conviction. So can you address how those interplay on getting to that heightened level of a willful violation?
Yes, so this case is a textbook ELC 10.14c case, and that rule provides that when a lawyer is charged in a disciplinary case with misconduct for which they were convicted in a criminal case, the conviction serves as conclusive evidence of their guilt of the statute for which they were convicted in the commission of the crime. This court has also found in In re Vanderveen that the level of culpability in the criminal statute in a case like this is proven by virtue of the conviction. So here you have, in the case of the false income tax returns, required a willful state of mind. The fact of the conviction is sufficient for the disciplinary proceeding to establish that Mr. Kelley acted willfully, because that was proven beyond a reasonable doubt in the criminal case. And that's a higher burden of proof than is required in discipline. The state of mind of willfulness, again in re Vanderveen, the court found, equates to intentional conduct for purposes of applying disciplinary sanctions.
But the same is not true of count 1, right?
Count 1 did not, the possession and concealment charge did not include, a willful state of mind in it. But again, when this court is reviewing the sanction de novo and it's applying the ABA standards, ABA standard 5.11a is silent on state of mind. The state of mind, unlike other ABA standards, is not a factor for that particular standard, because it requires or presumes that disbarment is the suspension, or is the sanction, when a lawyer has been convicted of a serious crime, including a number of elements. Whether the state of mind in that statute was knowing or willful or intentional isn't relevant to 5.11a. It is relevant in 5.11b. And the hearing officer here did find independently that Mr. Kelley acted intentionally with respect to all 8 counts. So under 5.11a or b, disbarment would be the presumptive sanction.
But the hearing officer had...
In regards to these convictions, if the individual has a serious conviction, there is no discretion in regards to the sanction. Does it mean the conviction? We don't get into the mens rea, it's conviction, and then we're dealing with disbarment. What is the discretion the hearing officer has to apply when there's a conviction? And when the hearing officer is exercising the discretion, I'd like to know, how do they view when the behavior occurred and when it's now before the hearing officer time, the passage of time, factor in to that analysis?
So in answer to your first question, Justice Whitener, it's not that there's a complete lack of discretion. The hearing officer, when presented with evidence that a lawyer has been convicted of a crime, needs to consider what the crime is and consider how, if at all, it violates the rules of professional conduct. Here, the hearing officer did that and found that for all 8 counts, Mr. Kelley violated RPC 8.4b, 8.4c, and 8.4i. The hearing officer can then consider and should consider aggravating and mitigating factors. They apply the ABA standards to determine the presumptive sanction and consider the aggravating and mitigating factors. So it is not a case where a conviction automatically equals disbarment. There are cases where lawyers have been convicted of crimes that do not result in disbarment. I will say the vast majority, particularly of felonies, have resulted in disbarment over the years. Mr. Kelley hasn't provided any cases demonstrating the disproportionality of disbarment in this case. With regard to your question on the passage of time, one potential mitigating factor under the ABA standards is delay in disciplinary proceedings, which does tend to consider the passage of time. That only applies when there has been undue prejudicial delay by the prosecutor, essentially ODC in this case. There was no evidence presented at hearing that the mitigating factor of delay in disciplinary proceedings applied here, and the hearing officer didn't find it.
For instance, if I can just follow up briefly, in an instance where an individual is facing sanctions for a crime that was committed years ago, there is no repeated offensive or misconduct as is required. The hearing officer doesn't take into account the fact that in that time period, there have been no additional offenses as they would in a criminal proceeding. Is that what you just indicated?
The hearing officer could consider such information if it was presented by the respondent lawyer. It was not presented here. It's nothing in the record about it. The mitigating factor of delay, applies to the disciplinary proceeding, but in a case such as this, when there is a criminal trial and lengthy criminal appeals, typically the disciplinary case is going to necessarily follow perhaps many years after the criminal case has run its course. A respondent could try to present such evidence and the hearing officer could consider it and give it whatever weight they may, but that's not in the record here.
May I pause and ask the bailiff, do you know how much time is left?
1 minute, 50 seconds, sir.
Thank you.
Thank you. Here, the court will review the sanction de novo. It will apply the ABA standards and consider the aggravating and mitigating factors. It will then consider the degree of unanimity among the disciplinary board and the proportionality of the sanction. Mr. Kelley raises an issue with the board's 5-3 decision. Appears to argue that they are required to be unanimous, but there is no authority to support that. A unanimous board decision would be entitled to great deference, but a split board, as there was here, does not necessarily work in Mr. Kelley's favor. It just lessens the degree of deference the court gives it. But the court is going to do its own de novo review of the sanction. In reviewing the ABA standards and aggravating and mitigating factors, the court should determine that disbarment is the appropriate sanction here. Mr. Kelley has not presented any cases to demonstrate that disbarment would be disproportionate for the 8 federal felony convictions here. These are crimes of dishonesty. As far as the purposes of lawyer discipline regarding the protection of the public and the integrity of the legal profession, it would send a terrible message to the public for this court to determine that a lawyer who has been convicted of 8 federal felonies, all of which are crimes of dishonesty, would be allowed to continue practicing law and would not face disbarment as other lawyers have. So we ask the court to impose disbarment to adopt the hearing officer and the disciplinary board's recommendation in this case.
Thank you, counsel. Rebuttal, please.
With regard to the questions of disbarment and then being reinstated, the bar has been fighting since 2018 for disbarment at every step of the way. It would be difficult for me to believe that they're going to change their mind tomorrow and I can be reinstated. I don't know if that includes taking the bar and a whole host of other hurdles to jump, but I do think that's an important point. With regard to...
Can I ask you about that? Because you may be talking about two different things. I clearly heard the bar saying they would not regard the amount of time that you've been suspended, or that it's not relevant under the rules to mitigation of the sanction. In fact, I think he said it would short-circuit the process that otherwise applies. But do you disagree that under, I think he said it was Chapter 25, sorry, I made a note, of the APRs, about what happens after disbarment, do you disagree that you would be eligible to apply for readmission and go through the character and fitness process?
I believe it's up to their discretion. I don't think I'm, quote, eligible tomorrow. I think they need to consider if that's going to be the case, if I can apply tomorrow. And then if so, why would they change their tune from today, where they're fighting for disbarment, for the last 6 years?
But that's, I guess, what I'm getting at, is I don't see why that's changing their tune. They're saying you should be disbarred.
Yep.
Whether you can reapply and be readmitted through the APR process is not before us.
Correct.
And so you agree with that?
I agree that process is not before you today, correct. So if there is a disbarment and then I can apply tomorrow, I don't think the bar is going to say, oh, yeah, you're good to go. That's my opinion in terms of consideration here. That's why I'm fighting so hard here. Again, I've been suspended for 6.5 years at this point. I do want to address a couple quick issues just in response, 4 questions hopefully. The first is a delay. I don't make the argument that ODC delayed. I make the extreme argument that the federal prosecutor delayed. The fees that I set were set in 2002. The charges in question were from 2006 and 7. The indictments from 2015, the convictions from December 2017. So I do think that delay should be looked at this. With regard to either multiple offenses or continuing conduct, I don't think there's any question that there's none of that. With regard to the fees charged, the fee was set once. Should it be a one offense? But the fee was charged through my company thousands and thousands of times. Should it be thousands of offenses? I would argue no. And just to ask the court to take judicial notice of any of your personal refinances at your homes or any sale of property, this reconveyance fee is still being charged today. Again, the conviction stands, I understand that, but the fee is still being charged today.
Were there any specific mitigating factors that you argued besides lack of prior discipline and reputation and good reputation and character?
I did argue the other penalties that have been imposed on me. ODC said they don't matter, including death threats, solitary confinement, which I would argue, should be considered. That was one thing I argued. Absence of the prior disciplinary record, particularly being under the spotlight here, getting a lot of different political complaints and having nothing sustained or even coming to any level before a straight dismissal. I do also want to address the character and reputation issue. As he said, the mere presence of that factor, I would argue this case is a little bit different. I have not been in the private practice of law for my entire life. My entire life is devoted to public service, other than a couple different business ventures, of which this is one. I was in the legislature for 6 years. I was the state auditor for 4, and I've served in the military 28 years, active reserve and the Guard. So I think those factors make it a little bit different than the mere presence. So I would argue, please take a look at the mitigating factors. I do want to address the issues from Justice McLeod. Certainly there's no concealment that can be argued here. Yes, they're charged conjunctively, but convicted separately. And just to make that point, to drive it home, I filed PDC disclosures, Public Disclosure Commission disclosures, from 2005 to 2017 with these funds. Every tax return from 2008 until I had the funds were disclosed, and including disclosed in previous civil litigation, which we won and was dismissed, brought by former U.S. attorneys who then brought the case. Again, I just wanted to hit on that issue.
Counsel, before your time runs out, I was interested in that first charge again, the defendant possessed or concealed property. Isn't it required, though, that in order to convict, the jury has to be convicted that the defendant knew that the property had been stolen, whether they concealed it or possessed it? Either way.
You read the quotes that were read to the jury, including one by the judge itself.
I don't care about what the judge said to the jury. It would be the instructions and what the statutes or what the law requires for a conviction. Isn't it true that the law requires, under this charge, that the defendant knew that the property had been stolen, whether they concealed it or possessed it?
You know, I can't say that 100%. I believe that's what the statute probably says.
Right.
But in terms of how this was presented, I charged a fee. They said it was supposed to be refunded. They said everyone refunded. They later agreed that was not the case.
I understand that, but we're assuming that the convictions stand for the,
They stand presently, though I'm
Right.
fighting both judicially and executive order, which is not really before this court today. So just to clarify that issue, we agree, I agree, I think everyone agrees that I intended to charge those fees. I did the work required, and I kept the fees. There was then an argument that, based on implied contractual theory of third-party beneficiary, that the money should have gone back. That's what they argue. Do I have knowledge of that and know that? I guess they have to make that argument.
right. So they would have had to prove to the jury that you knew the property was stolen, regardless of whether you possessed it or concealed it. That's what the statute requires.
That's what the statute would
Proof.
require, I believe, yes.
And you were convicted.
Correct.
So presumably the jury believed that you had knowledge.
That's difficult to say when a jury member sat with my wife at the sentencing. It's difficult to say when a juror wrote a letter to the judge saying this is not an offense that there should be any jail time for. It's difficult to say. Also, it's difficult to say when the attorneys found out that votes were traded in order to get rid of the money laundering charges at the end, when the second Allen charge was issued to the jury a couple days before Christmas, the last business day. So it's difficult to say. But yes, that is what the federal statute requires. I do not disagree.
Thank you.
Subject to your questions, thank you for your time.
Thank you for your arguments. The case is submitted. We're in recess for 10 minutes.
All rise. The Supreme Court is in recess.